Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, everyone, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Lexi Michaud, and today's topic is, can a price be put on harm? FTC monetary remedies and the data-driven economy. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Lexi.
Can you please introduce our guest for the day?
Sure, it's my pleasure. We have two guests today. First, we have Laura Riposo VanDruff, who is a partner at Kelley, Drye, and Warren, and she's a managing partner of the firm's Washington, D.C. office. She advises companies on consumer privacy, data security, and regulatory enforcement matters. She previously spent nearly a decade at the Federal Trade Commission and also held a senior legal role at AT&T. And our second guest, Mike LeGower, is a director at NERA Economic Consulting, specializing in consumer protection and competition economics. He previously spent over a decade at the Federal Trade Commission as well, where he served as the Deputy Assistant Director in the Bureau of Economics and led an analysis of cases involving deceptive marketing and unfair practices. He advises clients now on litigation and regulatory matters, drawing on extensive experience in economic analysis, empirical research, and high-profile enforcement actions.
Thanks, Anora. Laura, Mike, welcome to the show. Thanks so much for being here.
Thank you for having us, Lexi and Anora.
So I'm going to kick things off with a question to Laura. So to start, can you provide some background into how the FTC historically sought monetary relief in consumer protection and privacy cases, and how the Supreme Court's AMG capital management decision 5 years ago now altered the FTC's ability to seek monetary remedies?
Sure. So, I think I need to wind the tape back just a little bit.
Please,
the Federal Trade Commission's, Section 13B of the Federal Trade Commission Act really was its workhorse for the Commission. It was added to the Act in '73 and on its face authorized the agency to go directly to federal court to seek permanent injunction against ongoing or intermittent violations of laws that the agency enforces. And starting in the late 70s, the agency began interpreting that permanent injunction language expansively, reading it to authorize not just prospective injunctive relief, but also full equitable monetary remedies, including restitution and disgorgement. And it did so without first completing administrative proceedings, which is contemplated by another provision of the Federal Trade Commission Act in Section 19. So for 4 decades, effectively my entire life, this became the agency's primary enforcement tool across a sweeping range of consumer protection cases. In 2019, by way of example, the FTC filed 49 complaints in federal court and obtained hundreds of millions of dollars in redress or disgorgement through Section 13B actions. AMG Capital Management, and I don't want to belabor the details, was a unanimous opinion holding that Section 13B's permanent injunction language authorizes only prospective injunctive relief, not retrospective, equitable, or other monetary remedies like restitution or disgorgement. And for the compliance community, the impact was immediate and concrete. So AMG stripped FTC of what acting chairwoman Becca Slaughter at the time called the strongest tool that the commission had to help consumers when they needed it most. After AMG, enforcement actions could no longer yield those quick, large dollar monetary recoveries through the courts.
Since AMG, has the FTC continued to seek monetary remedies? And if they have, how are they doing so?
So the short answer, Lexi, is yes, but it's more complex. The commission needs to consider multiple tools to evaluate what is most appropriate in a given most appropriate to a given set of facts. So the commission didn't accept AMG as the end of monetary enforcement. It pivoted to using other statutory mechanisms to maintain financial teeth in its cases. Indeed, then Chair Lena Khan issued a memo to commission staff directing that after AMG, the FTC should utilize its full set of tools and authorities. So they fall into effectively 4 buckets. We've got Section 19 administrative redress, penalty offense authority under Section 5M1B, civil penalties tied to statutory violations, and we've seen the Commission use that quite a bit in the last year, and then enforcement of consent orders where, that also allows for civil penalty. Happy to get into any of those, but those are the principal tools that FTC has at present.
Great. And from your perspective, I guess I'm wondering if you see this shift since AMG as a stopgap or more of a permanent shift in enforcement strategy.
Well, certainly the fact that there was a tool removed from the FTC's toolkit is itself significant. But I think it's also important to evaluate how the Commission has responded in 2 separate administrations, both under the Biden administration and under the Trump administration, different leadership at the Commission. So, thinking about the current administration, one thing that has stood out to me is the institutionalization of the FTC partnering with state AGs as a monetary enforcement channel. And that, getting to your question, isn't merely a stopgap. It's a durable enforcement architecture because, of course, the state AGs have different ability to seek monetary relief on behalf of consumers. The FTC is formally committed to working with state attorneys general and other consumer protection officers as a force multiplier. And we've seen Chair Ferguson accelerate the practice concretely. So just by way of example, the Federal Trade Commission in a number of states jointly sued an online ticket marketplace seeking both monetary and injunctive relief. And that was a combination of FTC Act authority and the consumer protection statutes in each state. I'll also mention that rule-based civil penalties are very much at top of mind for this commission. The emphasis, of course, has shifted from new rulemaking, although I think we're going to touch on that a little bit, to the enforcement of existing rules like COPPA and the telemarketing sales rule. So we also are seeing this chairman enforce a relatively new rule, the so-called junk fees rule, which was finalized in the prior administration and went into effect in May of 2025. He's committed to vigorously enforcing that.
Thanks, Laura. And just as, someone who doesn't practice this area of the law much, and for our listeners who are less familiar, can you just tell us briefly what COPPA is?
Oh, sure, of course. It is the Children's Online Privacy Protection Act that governs the collection and use of data for children under 13. It was enacted in 1998. The rule, the COPPA rule, was first finalized in 1999, and the FTC has historically enforced this vigorously, and this commission in particular has really leaned into protecting children online.
Thanks, Laura. I'm afraid we're going to have to get into more technical terms now. Turning to you, Mike. You advise on the economics behind these remedies. Since the AMG case, have you seen any changes in terms of how to calculate the monetary relief?
Yeah. So, from the outside, we often don't get to see how the sausage is made, right? But I can tell you from my 4 years post AMG at the commission, I didn't notice much of a change in how the economists go about their day-to-day work. The charge in the Bureau of Economics has always been to sort of use the best data that we have available to estimate how much consumers were harmed or how much companies profited from whatever violation is at issue in the proposed complaint. So I could talk a little bit about pre-AMG and I could talk a little bit about post-AMG. I'm not a lawyer, so I'm gonna trust Laura to step in if I make a misstep here. But pre-AMG, when most of the proposed complaints were styled as FTC Act violations primarily, The equitable relief that was available under Section 13B, which was the subject of the AMG decision, was more or less tied by doctrine to consumer injury or ill-gotten gains by the company of the practice, right? So basically trying to restore the parties to their initial positions before any of the violations occurred. Post-AMG, as Laura alluded to, many, if not most, of the proposed FTC complaints that we see come out will include counts alleging violations of other statutes. Laura mentioned COPPA. I'll rattle off a couple more acronyms and try to explain them to you as well. We have ROSCA, which is the Restore Online Shoppers Confidence Act that deals with negative option marketing. We have Graham-Leach-Bliley, which deals with, primarily in the context of FTC complaints, deals with obtaining people's credentials under pretexts. ECOA, the Equal Credit Opportunity Act, and the FCRA, which is the Fair Credit Reporting Act. So all of these tools have been used to add counts to complaints that give the commission civil penalty authority. So those rules have this attendant civil penalty authority that allows for a quicker route to monetary remedies than the Section 9 route or Section 19 route available for FTC Act violations. And those civil penalty amounts are not tied to injury or harm necessarily, except by convention. They usually are dictated by statutory per violation civil penalty amounts. So what has increasingly been added to the BE economists' charge is to calculate the exposure of the companies to those civil penalty amounts by taking the sort of maximum statutory per violation amount and summing it up over the number of violations or the duration of violations and things like that. But in addition to sort of the equitable relief doctrine that sort of ties the pre-AMG relief to harm or ill-gotten gains, there's sound decades-old economics research that sort of advocates for tying fines in general in law enforcement to consumer injury or ill-gotten gains in a proportionality sense. And that's not so much true for these statutorily determined civil penalty amounts. So when you have an independent Bureau of Economics that's providing memos to the commission, advising them on particular settlements, you tend to still see them writing memos that, or giving advice to the commission that highlights the consumer injury or the ill-gotten gains from the violations. What has happened since AMG is that the Bureau has gotten pretty practiced at estimating those types of harm or that ill-gotten gains for conduct that runs afoul of these new sort of statutes that are popping up in the complaints. So, the Bureau has gotten very practiced at computing or estimates of harm under ECOA or ROSCA, for example.
Thanks, Mike. That's very helpful. But in large privacy or data cases, we may be talking about like millions of people scattered around the nation, and then harms that's not purely financial, right? What kind of evidence or metrics have you found to be actually working to be helpful to demonstrate harm in a way that regulators and courts, to help them find credible?
So in data security cases, I'm gonna sort of treat these as two separate buckets, right? There's sort of data security issues and there's privacy issues. In data security issues, the Bureau of Economics and as a result, outside consultants have developed a pretty standard playbook of how to sort of think about injury in data security cases. Incidentally, I know we're going to talk about the February workshop on informational injury. In that workshop, they talked a little bit about this sort of process. But typically there, we're looking at several elements in sort of a chain of causation between the violations that the FTC is alleging and the sort of proposed harm to consumers. So those elements in the chain are, first, how much did the practices at issue affect the probability of a data breach? Second, how much does a breach affect the probability of subsequent identity theft or bad outcomes for consumers? And then finally, what's the harm in the event that one of those outcomes occurs? And so for the latter two elements, how much does a breach affect the probability of identity theft and how much does an identity theft hurt when it happens? We've had pretty decent evidence from surveys and other sources of that kind of information. On the first part, how much do the practices or the violations lead to risk of data breach, the evidence has not been as good. Although some participants in the workshop suggested that that's even that part is getting better as we get more information on how, companies' data security posture and things like that, and how it leads to breaches. So now I'm going to turn to privacy. In privacy, it depends a lot on the individual, the context of the data collection, the data being shared. In some cases, there may be explicit markets available for the kind of data at issue where we can use the prices in that market to get a sense of the value of the data, at least to the publishers and advertisers who are using it. But that's generally not going to be directly tied to the value that people might put on whether the data is shared in that context, right? That value tends to be highly idiosyncratic. It varies from person to person. It's highly context dependent, so it depends on the nature of the data and the sharing. So for example, when children's data are involved, there's a concern of the sharing of information that would lead to threats of physical violence or things of that nature, as can be the case with location data sharing. People are likely to place much greater value on their privacy, which makes total sense, right? And they may base that value on objective risk, right? That they understand that like children are particularly vulnerable and location data is particularly sensitive. In other cases, a person might simply just not like a particular data sharing practice, and their valuation is based on their own feelings or their own emotions about this topic, and their willingness or unwillingness to accept trade-offs for privacy. So it's clear that there's potential for harm from these sorts of privacy violations. But unlike with the financial harms, where more or less everybody agrees on the value of the harm, there's no surveys or markets that sort of document either the likelihood or the expected harm of, say, stalking caused by unauthorized location data sharing, or things like that. So quantifying those kinds of privacy harms becomes very difficult. And I think, the economists at the Commission have tended to shy away from sort of making definitive statements about sort of per person harm in those types of scenarios.
But Mike, to your point, beyond individual cases, and obviously there needs to be a case by case analysis, but beyond individual cases and to try to give everyone a better understanding of how to quantify harms, I think there's a broader conversation about whether the FTC should lay some kind of clear guidance, something that looks like, the merger guidelines in this context, a document that explains how the agency's thinking and thinking about these concepts here in the context of injury and remedies. So if you were to help design that sort of guidance, what building blocks would you expect to see in that kind of document moving forward?
I think this kind of idea came up frequently in the sort of conversations post-AMG, right? The sort of post-mortem and the hearings on the Hill about the potential restoration of 13B authority, right? There was a section of Congress that sort of wanted to implement guardrails on any sort of restored 13B authority, and that could come in the form of this kind of guidance that you're talking about. I think the foundation of any such document, first, is that, would be that monetary relief would be tied to the consumer injury or the ill-gotten gains at issue in the violations that are being proposed, right? In a proportionality sense, right? It doesn't necessarily have to be strictly equal to the harm or the estimated harm, but it has to be proportional in some way. And that the estimation of ill-gotten gains or consumer injury fundamentally requires creating a sort of a counterfactual or a but-for model of consumer and producer behavior in the absence of the violations in order to determine how much better or worse off consumers and producers are as a result of the violations. So that first idea that sort of monetary relief should be tied to injury or ill-gotten gains, that goes way back to the economics literature in the 1960s, right? And it's been developed quite a bit since then. The second idea goes back a ways as well, but sort of as folk wisdom and has only really been formalized in the past 10 or 15 years. So those are the sort of principal keystones that should be in any sort of guidance. In terms of details, it gets a little trickier. But I think there are some excellent case studies that have come out of the FTC in the Review of Industrial Organizations annual Economics at the FTC series, often consumer protection economists will write up particular cases and how injury was estimated in those cases. And I think those could serve as useful guidelines for how the economists at the FTC think about how to estimate consumer injury in a wide range of scenarios.
And do you,
as an aside, Lexi, I rely on Mike and his colleagues at NERA for folk wisdom of a great variety.
So do you, Mike, think that a more explicit framework would make outcomes more predictable for companies and enforcers, or would the facts of particular cases still drive most of the variation?
I think they could. And in general, I think there are sort of trade-offs to publicly committing to guidance or a framework like the one we're talking about. On the one hand, I do think it would reduce uncertainty to some extent. It depends on how concrete the guidance is, obviously, but any sort of guidance is going to reduce uncertainty to firms when they're considering their exposure to FTC litigation. So they have some sort of established framework that they can reference and do some homework about, what kind of monetary demands they might face in settlement negotiations with the FTC. Incidentally, it would probably also help the agency to lobby for the restoration of its 13B authority when there are critics out there who are worried about combining the sort of broad, unfair and deceptive acts or practices, UDAP authority that the FTC has, with the ability to obtain equitable monetary relief that's not necessarily tethered to anything concrete, right? So having that document in place that sort of concretely ties the equitable monetary relief to some estimate of consumer injury and a methodology for estimating that, I think would be helpful in the FTC's pursuit of its restoring its 13B authority. On the other hand, it does tie the FTC's hands somewhat, right? If a novel theory of injury comes up that wasn't anticipated by the framework that was released, the targets of any investigation under that theory could raise an argument that the FTC isn't really following its own rules, right? And hasn't given them fair notice that this is a type of injury that they're considering or the methodology for estimating that injury. Also, unlike with merger review, where the merger guidelines give great guidance to firms, there isn't decades of academic research discussing sort of the quote unquote right way to estimate consumer injury from deceptive acts or practices, right? There just isn't that established literature in the economics community to draw on. Those models that we do have often require a level of data that isn't often available to the enforcers. So my guess is that your intuition is correct and that any attempt to sort of comprehensively lay out a framework would necessarily be very high level and therefore sort of limit its utility to firms. But I think any sort of guidance would help. It might not be as specific as firms would like.
Everything we talked about is obviously very current and something that the FTC is paying attention to and trying to gather learnings from everyone on. So for instance, on February 26, 2026, the FTC held a full-day workshop on consumer injuries and benefits in the data-driven economy. So with that focal point, it pulled together economists and other experts to talk about how to value data-related harms and benefits, from data breaches to targeted advertising to privacy preferences. So for people who have not, being able to actually attend the full day workshop or learn more about that, Laura, perhaps we can benefit from your learning. What were the central questions or focal points that the FTC seemed to be wrestling with when it talked about injuries and benefits in a data-driven economy?
So Mike has alluded to much of this, but at its core, the workshop was wrestling with a simple but consequential question, which is how do you define and measure harm in a world where the currency of the economy is data? So we saw Chairman Ferguson open the workshop by framing the problem. How should data be valued? How do you determine what constitutes harm when consumers do not fully understand how their data is collected or used in the first place? So what I took away from the workshop is tension, a deep tension at the heart of modern privacy regulation. The same data that can harm consumers, and Mike talked a little bit about that, are often data that also deliver concrete benefits to consumers. I'll say this workshop in February was not one that treated data collection and use as presumptively harmful. Rather, the workshop heard that harm mitigation policies can, for example, reduce efficiencies, competition, consumer benefits, and that regulators should really think about those as opportunity costs and social harms associated with restrictive privacy laws. The workshop also signaled what I regard to be something of a philosophical shift in the current FTC's approach to privacy. So we heard from the director of the Bureau of Consumer Protection, Chris Muffarage, and he stated explicitly in his closing remarks that the FTC's privacy work should empower consumer choice, and that prior efforts to impose substantive limitations were misguided. That was notable. The workshop also made clear that FTC has not resolved and might not be able to resolve a measurement problem that really undergirds all of this. So a consistent theme across the panels was that data needed to reliably assess harm and benefit doesn't exist yet in sufficient quantity or quality. And again, Mike alluded to much of this. Consumer privacy preferences are highly contextual and dynamic, making them really difficult to measure. The panels also addressed, wide spectrum of consumer harms, from identity theft, emotional distress, physical harm, each subjects that Mike touched on, and how stronger, for example, enterprise level security could be associated with better outcomes, with a real emphasis on the NIST cybersecurity framework, highlighted as a benchmark for evaluating companies' information security practices.
Laura, could we learn anything from the workshop in terms of, if a company finds itself under investigation in a privacy or a data case in the near future? What should they expect in terms of questions about consumer injuries, about consumer benefits, based on what you heard at the workshop, based on the themes that you just laid out for us?
Sure. And I'll also just reflect on what we're seeing in practice in non-public investigations. So just as a preliminary matter, civil investigative demands, which are the FTC's principal way of obtaining information in their non-public investigations, they today go beyond documents and sort of threshold information, and this has been true for a while, but they're increasingly seeking quantitative data about how a company values, uses, and monetizes information. So in addition to that, what I'll also mention is the Bureau of Consumer Protection has made clear in this administration that it intends to enforce its CIDs. We saw the Bureau Director issue a blog post on this, and there have been other actions to really encourage industry to work cooperatively in FTC investigations. Mike has shed really important light on, how the Bureau of Economics interfaces with the Bureau of Consumer Protection in these matters. But, candidly, it isn't in any way transparent to the legal practitioners who are representing clients, exactly what the Bureau is doing with the quantitative data that FTC is collecting. I'll say that the workshop, in response to your question, Lexi, made clear that FTC is investing in their capacity to evaluate empirical harms. And of course, BE is at the center of that. The workshop also signaled that, and this is a really critical practice point, that the companies can and really should affirmatively raise economic arguments, including benefits that data practices offer, not just to rebut harm allegations, but to think of it as an affirmative argument. And that's a material shift from the enforcement posture of the most recent administration under Chair Khan. And it really creates a strategic opening for companies who are under investigation. And Mike and his colleagues contribute to that, as well as economists supporting other companies in this space. So the bottom line for companies is that the investigative framework is becoming more economically rigorous. The questions, we're seeing more quantitative questions, and the stakes of responding to a CID and a consumer protection investigation are high. And so, really, responding to the CID isn't a rote exercise. It really is developing a factual record in which economic data can shape the FTC's theory of harm.
Thanks, Laura. And turning to you, Mike, and still, I guess, building on the learnings from the workshop, but connected to what you have discussed before, which is the nature of the harm in many of these data-related cases. The harms are not straightforward as losing money in a scam, right? Like, paying a ransom or something like that. But they can be intangible, like loss of privacy, just having your information being posted around the world, and then increased risk of such exposure, for instance, after a data breach. How did the FTC workshop in February suggest that we should think about these kinds of harms?
So I'll say that economists have thought for a very long time about sort of valuing consumer welfare in situations where the effects of a policy are intangible. As you say, and this was accelerated tremendously in the 1980s and 1990s when cost-benefit analysis and regulatory impact analysis sort of came to the fore after, the various executive orders that mandated those kinds of things. So those methods have focused mostly on eliciting people's preferences for these intangible goods through hypothetical choices. And so this is sometimes called stated preference methods, right? The problem with valuing the loss of privacy has historically always been that when we put these stated preference methods to use, the answers that we get vary a lot according to the context, and are sometimes seemingly inconsistent with people's decisions day to day that they make when they're trading off privacy for goods and services of value. And we would call that kind of evidence revealed preference evidence, right? People are revealing through their market decisions what their preferences for privacy are relative to their preferences for goods and services.
And in the privacy literature, this is referred to as the privacy paradox.
Correct.
Yeah.
I was just, you stole it from me, Laura.
Oh, I'm sorry, Mike.
Right. So this gap is sometimes referred to as the privacy paradox. I think many of the researchers at the workshop were pushing back against this idea that there's even the paradox at all. Right. And so what they were doing in pushing back was either citing to new evidence showing that people have significant valuations for like privacy protecting interventions, or reframing the issue to highlight the fact that the people in these hypotheticals may be expressing sort of aspirational preferences about privacy if we were starting from square one, while still acknowledging that, when you're making decisions in the marketplace, there's no way to put the toothpaste back in the tube, right? Your data is out there, and your low willingness to pay for any sort of marginal privacy protections is rational, right? Because you expect that your data is already being widely shared. And so in that sense, it wouldn't necessarily be a paradox at all, right? It's just that when people are asked about how much they value privacy, they think about it in general and not on the margin.
We're running out of time, and we do not want to lose the opportunity for our audience to learn about you, just on your opinions and insights on the substantive topic. Also, they want to learn about you as a person. So perhaps we start with you, Lauren. If you can tell us one thing that people have only worked with you or only known you professionally would not have known, what would that one thing be?
Well, if I could tie this together neatly, I'd have a privacy paradox anecdote, but I don't. Instead, I'm going to relay what I've been thinking about since the Olympics and Alyssa Liu's remarkable performance. So when I was very young, I was knock-kneed, just enough that my pediatrician had my parents bind my feet together at night, a practice that pediatricians do not do anymore. And as I grew up, it was important to the pediatrician that I engage in non-contact, non-impact sports. So my parents pushed me into figure skating. And as I got what I'll say is I was not good. I had no natural talent. No one ever said she's a prodigy. I had no goals of Olympic skating, but I did have determination, and I spent a lot of time on the ice in central New York, where somehow skating rinks were warmer than being outdoors. I eventually learned how to cut my edges, spin without falling down, land basic jumps. And I kind of looked like a figure skater, which at least counts for a lot as I watch these remarkable athletes participate in the Olympics. And I think that perseverance as a child really taught me a lot. And but it's not a story that I share often because I remain not very good. So that is my anecdote, that it has nothing whatsoever to do with privacy or consumer protection.
I'm sure you're being modest. I'm sure you're great on the ice. And as an antitrust practitioner, it's all about market definition. Can you be the best figure skater in your family if we define it as NERA as NERA?
That's an excellent point. Yes, many of them would just fall over. Correct.
All right. Let's turn to Mike for a second. What would that one personal thing or thing that people have known you, only professional, would not know about you?
So you might notice that most people have a bookshelf behind them, but what I have behind me is a whole shelf of board games. I'm a very avid board gamer. I've attended several conventions over the years, going to see the latest and greatest new board games and seeing expo halls filled with board game vendors and things like that. So that's one thing that many people who have worked with me probably don't know.
Is Monopoly one of those, or is that too basic?
No.
No?
Terribly designed board game. You don't want to get me started, Anora.
Well, that's one more thing we need to ask about you in a future Our Curious Amalgam episode. Thank you so much, both of you, for joining us as guest speakers, and thank you, Lexi, for wonderful co-hosts, as always. And thank you, audience, for tuning in or watching us now. We will see you again until next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.